begin. And I'd like to introduce Eleanor first, who will introduce our presenter and our session for today. Thank you.
Good afternoon, everyone. We have back with us this year, and it's my pleasure to have Anastasia Greene, who is a clinical law fellow in immigration. She runs the immigration clinic at UF Law School. Her focus today is going to be on two cases which were decided by the Supreme Court and have impacts for immigrants that all of you should understand, because you may be asked to help at some point with someone who falls into this category or these categories. The first one, the Niz-Chavez case, really offers new hope to thousands of long-term immigrants seeking to avoid deportation. The ruling of the Supreme Court faulted the federal government for improperly notifying a man who came to the United States illegally from Guatemala to appear for a removal hearing. In a 3-6 decision at that time, I don't know if we would get it today, but it was a 3-6 decision. The court decided and overturned a lower court decision that had prevented the immigrant from pursuing his request to cancel the attempted expulsion based on the length of time he had lived in the United States. He actually lives in Michigan with his family, and he entered the United States illegally in 2005. So the conservative bloc actually went along and helped form the majority for this decision. The other case that Anastasia will be discussing is Sanchez. And the US Supreme Court has heard oral argument. Anastasia, have they decided that case?
We have, yeah.
Okay. And this is whether individuals who initially entered the United States without permission and subsequently were granted what we call TPS, or temporary protected status, are eligible to adjust to lawful permanent resident status without leaving the United States. These two cases have great implications for immigrants. And Anastasia will walk you through what was decided, the impact, and where the court may go with these types of decisions in the future. So with that introduction, I turn the presentation over to Anastasia.
Okay, hello, I'm Anastasia Greene. It's nice to be with you all again. I remember some of you from last year as well. And so today I'm going to be talking about two new cases that the Supreme Court has decided on immigration that can have some fairly big impacts. Okay, so this should hopefully now show the PowerPoint presentation, right? The Supreme Court immigration cases. And these are the name of the two cases that were recently decided: Niz-Chavez versus Garland and Sanchez versus Mayorkas. Now, these are actually fairly complicated cases. Almost every case is complicated. By the time it gets to the Supreme Court, that usually means that all the other judges at every other level weren't able to figure it out. So it has to go all the way to the Supreme Court for them to make a decision on it. But I'm going to sort of walk through the issues in this case so we can sort of follow along and we can help to understand how the Supreme Court makes a decision. You know, what is the logic that they use? What are the most important principles that they use to sort of see what impacts the decision and understand what's going to happen in the future as well in terms of how they make these rulings. Okay, and I'm going to be taking questions at the end as well regarding these cases or, immigration in general too. So if you have any questions, please feel free to ask them at the end as well. Okay, so we're going to start with the first case, which is Niz-Chavez versus Garland. So I just want to do an overview of the facts of this case first, and then we'll delve into all the different legal aspects, immigration law, et cetera. So this is just the actual facts in terms of what happened, okay? So in 2005, Augusto Niz-Chavez entered the United States without permission, fleeing violence in Guatemala. So he came to the US in 2005. He didn't have any immigration status when he arrived in the US, but he was fleeing the violence in Guatemala at that time. And he stayed in the US. So he stayed living in the US up through March 2013. Then on March 23rd, 2013, ICE, which is Immigration and Customs Enforcement, issued a notice to appear to Mr. Niz-Chavez that would begin the deportation process. So a notice to appear, it's almost like a summons in the criminal context. A notice to appear in immigration is a notice that says, the government wants to deport you, the government wants to remove you, and you must appear for immigration court. And it's just like any other type of proceeding. Then you have an immigration court hearing, you can offer your defenses, and eventually the immigration judge will decide if you're going to be deported or not. So this was what the notice to appear is. The notice to appear, the first one he got was March 23rd, 2013. So he got a notice to appear, but the notice didn't actually have a hearing date. So it didn't include a date or a time for his removal hearing. It was just a blank notice to appear that said, okay, we're starting removal. We're starting the deportation process, but we're not telling him exactly when that will begin. Then on June 25th, 2013, ICE issued a second notice. Now on this notice, it did have a time and a day for his removal hearing. He applied in the meantime for what's called withholding of removal and relief under the UN Convention Against Torture. So he alleged that if he did have to go back to Guatemala, he would be at high risk of being killed or being tortured if he would be forced to be removed or deported. I'm going to use these terms interchangeably. You're most familiar with deportation. That's, removing somebody from the country. The actual legal term is removal and expulsion, but for our purposes, I'll just use both. So to be removed and or deported. So he applied for this relief, right, based on the risk of death that he would face if he were returned. And then he had this final removal hearing. That was on June 13th, 2017. And at this removal hearing, he offered one more defense, which is called cancellation of removal. And we're going to go into a little bit what this is. This is a defense to deportation, a defense to removal. You can only offer it in front of the immigration judge, though. You can't try to file a petition for it ahead of time. You only get a shot in front of that immigration judge to raise this defense. So cancellation of removal, this defense requires you to live at least 10 years continuously in the United States. You have to be here 10 years living in the US to try to get cancellation of removal. The law has stated that your time in the US can end legally with a valid notice to appear. It can cut off. So you lived here 9 years, you get a notice to appear at year 9. That cuts off the time for you, even though you're still here. It cuts off the time that you can use to claim for cancellation of removal. So the government contended that his continuous presence in the United States officially ended on June 25th, 2013. That's the day he got this second notice, right, that has his removal hearing date. And the government said, okay, we think his presence in the United States officially ended. It was cut off in 2013. So this would have a major effect. We'll go into what cancellation of removal is really next, but I just want you to look at the time period here to see how much these little things matter a lot. So if the government is right on that, his presence officially ended in 2013, what is the period of time then that he can count his presence in the United States? It would be 2005 when he came, right, to 2013, June, when he got that notice. You add that up, that's 8 years of time in the US. For cancellation of removal, you need to be here 10 years. So he would be out, right? He wouldn't have been here enough time. Now, we see, when did he have his actual removal hearing? That wasn't until 2017 when the immigration judge actually ruled. So by that point, he'd been here from 2005 to 2017. That's 12 years, right? So if the judge holds that that notice to appear wasn't enough to stop his presence inside the United States, to stop the time for cancellation of removal, if they rule for him, that means he's been here 12 years at least, and he can apply for cancellation of removal. So it matters a lot, because based on how that turns, he's either only allowed to have 8 years here that he can count, or he can count 12 years. And cancellation of removal, you got to be here 10 years. He will win or lose that defense based on how long he was considered to have actually been here, okay? So the immigration judge on the original, at the court level and trial level, ruled that his presence in the US ended when he received that notice of hearing on June 25th, 2013. So even though he's still here, it's 2017, that cut off the time, that notice to appear cut off his time period that he can count towards presence, which means he was ineligible for cancellation of removal. And they actually ordered him to be removed from the country, okay? He appealed that. It went to the Sixth Circuit Court of Appeals, which upheld that decision by the trial court judge. And he appealed it again up to the Supreme Court. And then on November 9th, 2020, the Supreme Court actually heard oral arguments to issue a decision on this case, okay? So they're deciding whether they should uphold that ruling from the original immigration judge and the Court of Appeals. His presence ended officially with that notice of hearing in June 2013, or rule for him that notice was not enough to stop his time accruing, and he can still claim the time now 12, 13, at this point, where is he at? He's at 15 years in the US. He can count all that time to get cancellation of removal. And in this case, the cancellation of removal would be the deal breaker in terms of whether he's going to be deported back to the US or can stay in the US, would be based on whether he can get cancellation of removal. And so one other thing I just want to point out here is this also seems like a little thing with, okay, when did these time periods end? But like, this is life or death potentially, right? Because he was also claiming that he would be killed or tortured if he were to be returned. So it's, even though this is a civil hearing, it's very much often a matter of life and death in terms of that individual person, in terms of what would be the effects of being removed from the US. Okay. Okay. So instead of just jumping into the Supreme Court case, which won't make any sense unless you know the backdrop here, what are the laws they're talking about, I'm going to be talking about what do I mean with these terms, okay? So we understand what the importance of this is. So the first term that I was throwing around is called cancellation of removal. What is cancellation of removal? Cancellation of removal is a defense to deportation or removal. The non-citizen raises that defense before the immigration judge in the removal hearing. And this is important to know, especially when you're thinking about the larger effects, because realistically, this is often one of the only defenses that are available to people. Like, let's say they're going to be put in removal or deportation. Now they can potentially raise cancellation of removal as a defense. And if they win, what do you get? You win big if you win. Because if the non-citizen wins, first, the removal is canceled. So the removal process, the deportation hearing, that's all canceled. And you get a green card. So that non-citizen actually what's called adjusting status, that means getting a new status. They adjust status to a lawful permanent resident, green card holder. So if you win, you're going to go from being somebody that's being removed from the country, that's canceled, and then you actually get a green card to stay permanently. So it's a very powerful remedy if you can get it. It's not an easy thing to get though. So here it has the elements. So let's say you have somebody, a client, or let's say you have somebody that's potentially at risk of removal, they want to see if they're eligible for cancellation of removal. And then these are the elements. If you were out of status, let's say you don't currently have a green card, you don't currently have a visa, or you just have a temporary visa, someone that entered without inspection, for example, as well, they could potentially qualify for a cancellation of removal. But these are the elements for them. Okay, and then this is the actual statute here. And so you have to have been A, physically present in the United States for a continuous period of not less than 10 years, immediately preceding the date of your application. So here it has, if he did his application in front of that immigration judge in 2017, he'd have to show he'd been physically present continuously in the US for at least 10 years, going back to 2007, right, to have that 10-year period. And we'll just look at these elements and even think about applying them for Mr. Niz-Chavez, how this would work for him. So would he be able to show he was present continuously for at least 10 years? You have to be a good person of good moral character. There was no question about that here. You can't have been convicted of a crime, which he was not. And finally, you have to establish that removal would result in hardship to a citizen relative, not that you would suffer hardship, but that you have a US citizen child, parent, or spouse that would be significantly harmed or would have a lot of hardship if you were to be removed from the country. And they established that as well. So the only question here was, could he show that he'd been here continuously for at least 10 years by 2017? So he got here 2005, that's 12 years at least. But what about that notice to appear he got in 2013 that started the removal? So when you saw that law, it says you have to show continuous presence in the US for 10 years. So what does that mean, continuous presence? How can you show continuous presence? What ends continuous presence? So for cancellation of removal, the person must have had at least 10 years of continuous presence in the US. What can end your continuous presence? Obviously, if you actually left the country, let's say you moved out of the US or you left the US for a long period of time, that's considered to stop your continuous presence in the US, just physically in the real world. But there's another way that you can stop continuous presence as well. And this would be true even if you've been in the US this whole time. This is what's called the stop time rule. And this is a statute that says your continuous presence ends when the alien or the non-citizen is served a notice to appear. And that's the actual statute. And then this is the language underneath that. Termination of continuous period. Any period of continuous residence or continuous physical presence in the United States shall be deemed to end when the alien is served a notice to appear. Okay. So for what this would mean then is that it wouldn't matter so much when are you here. The question would be, when were you served with a notice to appear? And so here we have the notice to appear. It actually begins the removal process. This is the statute. And the statute says what has to be in that notice to appear and how it has to be given to that person. It must be given to that person either physically, they knock at the door, they give it to that person, or it can be served by mail. But it has in the statute certain things that need to be in that notice. It has to have the nature of the charges. Why are you being removed? It has to have the date and time of your hearing. When do you need to appear for your removal hearing? What type of proceeding this is, et cetera. And that's all laid out in the statute, okay? So when was he, we'll go back here. Looking at the facts here. When did Mr. Chavez get a notice to appear? He got a first notice to appear March 23rd of 2013. But that didn't have a date or time for his hearing, right? And then June 25th, 2013, they gave him a new notice that now has a time and date of his removal hearing, but it doesn't include, it's not an actual, it doesn't have the title of a notice to appear. So would either or both of these qualify as a notice to appear to actually end his time period, to cut off his time for continuous residence? And that was the issue in this case, okay? why is this rule here? Why is the stop time rule in present? This started it was passed in 1996. And part of what the reason was there was a concern that immigrants may artificially extend the time of the hearing in order to accrue time, right? Like maybe they start the removal process 2017 and you may just file tons of baseless motions to start to drag on the process for another 3 years so that you can actually hit that 10-year period. I don't know how much of a problem this was, but that was the reasoning given. That's why they put in this stop time rule. So there's no possible way that once the immigration removal hearing starts, there's no possible way you could just drag your feet, right, and file a lot of things to actually make it an artificially long time so you can hit that deadline. So that's why it was deemed to begin with the notice to appear. Okay. All right, so here we've got these two notices, right? One did not have the hearing date and the second notice did. And then the issue in this case, if you crystallized it, this is how the Supreme Court crystallized it, is what qualifies as a notice to appear sufficient to trigger the stop time rule or cancellation of removal, okay? So were those notices that he got, were they sufficient? Were they correctly a notice to appear that would stop the time that he could accrue and would prevent him then from being able to get cancellation of removal? Okay. So the government's argument is, yeah, okay, maybe we did 2 notices instead of 1 notice, but who cares? We should be able to issue several notices as long as they together contain the required info. So the first notice didn't have the date of the hearing, which is what the statute requires. The second notice did have the date of the hearing. So the government's position is between the 2 of them, one notice gave him the notice of charge. The second one gave him his hearing date. Just call it a day. You know, cumulatively, those 2 notices gave him each of the required information that the statute requires if you combine them together. And so the government considered that his time stopped accruing when he got that second notice, June 23rd, 2013, that had the hearing date and time, because by that point, they had hit each of those required elements, that hit each of the information that needs to be on a notice to appear. Niz-Chavez's argument is that the statute requires 1 notice to appear that contains all the required information, that tells you the notice, what you're being charged with, when your hearing date is, et cetera. The government can't just issue piecemeal notices over time with some of the information. The government argued that they should be able to do more than 1 notice with this information, and they gave a lot of sort of logistical reasons. They said it's hard to put all of that information in 1 notice, for example, because they don't always know when the hearing officers will be available. They also said the time of the hearing may change over time, so they want to wait until they have that hearing date finalized and then send a second notice. And they said their own internal guidance and regulations say that it's okay. So what was the decision? April 23rd, 2021, Supreme Court issued its opinion, a 6-3 majority, authored by Justice Gorsuch. And the Supreme Court ruled for Niz-Chavez. And they found that notice to appear was insufficient to stop his continuous presence in the US. Those notices could not cut off his time accruing inside the US, which means that he could now actually do cancellation of removal. He could show he'd been here 10 years and he could apply for cancellation of removal and get a green card, okay? So what was the Supreme Court's reasoning? We'll get into that, but I just want to go about, before we do that, just looking here, the issue, what qualifies as, quote, a notice to appear, unquote, sufficient to trigger the stop time rule. The quote there is a notice to appear. That's a quote directly from the statute. And believe it or not, this entire case turned on what the meaning of a is. See how it said there's a notice to appear? It came down to, what does this mean? If it says a notice to appear, does that mean a notice to appear means you could do a couple different notices that has that information and that's a notice to appear? Or does it mean just one and only one? You can almost think of it as like, it depends on what the definition of a is. And lawyers a lot of times are considered somewhat, I'm not going to say shady, but having almost giving overly detailed information about or splitting hairs on what something means. But this is why that is true. It's because one word can mean a lot. And I think of like Clinton, like it depends on what the definition of is, which was roundly made fun of and deservedly so. But that's a very lawyer type of answer because they always want to know what is the definition of this one word. And you can see here in this case that the definition of A has massive consequences in terms of this case and other cases as well. Okay, so the government decided that when the statute says a notice to appear, that means that the government must issue one notice to appear that contains all the required information, including the date and the time of the hearing. The government can't just issue a series of notices with different parts of that required information. So the Supreme Court is reasoning. They look back to the statute. This is called statutory interpretation, where the court will look back at the statute and analyze, okay, what is the language of that statute? What does that language mean? The language in 1229A, which is the law about notice to appear, it says a notice to appear must be issued that contains these required elements. And so what does A mean? So the Supreme Court considered that A is an indefinite article for a countable amount. So for example, a notice would be one notice. If there's A is mean something that's countable, 1, 2, 3, 4. What would a notice mean? That would be, if you're counting, that would be one notice, right? And not a non-countable amount. For example, if the statute had said sufficient notice, that's not accountable. What's sufficient notice isn't something that you can count 1, 2, 3, 4, 5. Sufficient notice is sort of vague. It's not a specific amount. So if it had said in the statute sufficient notice, probably that would have been okay to give sufficient notice over various types of letters. But that's not what the statute said. It said a notice, a countable amount, which would be typically considered one notice. And they also compared it with other case initiating pleadings. So for example, this is what's called analogy by comparison, where the Supreme Court looks around and sees, okay, how have other similar laws been interpreted? So for example, in federal court, if they're issuing a summons to somebody for a criminal court case, can that be, several different summons, or does it have to be one summons? And they compared with other what are called case initiating pleadings that kick off a criminal case, for example, and none of them allow this to be sent in installments. All of them require just one summons that has all of this information. And then they also looked at the history and the structure of the statute. The statute that created that stop time rule, it was called IIRIA, started in 1996. And they looked at other places in that statute, and they found many different places in the statute. It said a written notice. It never ever said notices. It never said something like sufficient notice. And that statute also removed an earlier provision. So an earlier law said that the required information must be in the notice to appear or otherwise, meaning you could put it in the notice to appear or you could send it out separately. That was removed when they passed this statute, so that it said now this information must be in the notice to appear. So that also supports the intent of Congress to require one notice, right, that's going to have all of this required information, not something that's going to be sent separately. Also, the regulation on point that was passed, so there's a statute. The regulation is the agency's own guidance about what they need to do with that statute. And the regulation itself said that the time and place of hearing must be on the notice to appear. And the Supreme Court rejected the government's arguments. And if you read the opinion, it's almost surprisingly sarcastic almost about the government's argument that it was too difficult to issue one notice to appear with all the required information. Gorsuch stated that administrative inconvenience cannot justify departing from the statute's clear text. So here that they said the statute is clear. Congress has already created a rule for when does a notice to appear stop the time accruing, and the government has to comply with that law. And the Supreme Court said here, the statute itself required one notice to appear that has the date and time of hearing, the nature of the charge, etc., that stops the time accruing. Because the government did not do that, the time kept going, okay? And so what that would mean then is that Niz-Chavez is now eligible for cancellation of removal. He can show he's been here 10 years, even if they issue a new notice to appear now. He's been at least at this point 15 years in the United States, and he can receive cancellation of removal and a green card, which is actually what happened here. So Mr. Niz-Chavez actually ended up with a green card, coming from this position where he was being ordered removed and deported from the country. He actually reversed that and now has a green card. Okay. There was a dissent in this case. So the dissent was written by Judge Kavanaugh, Judge Roberts, and Justice Kavanaugh. Justice Roberts and Justice Alito supported the dissent. So what they said in this dissent was basically that this will impose too many administrative burdens on the government. They talked about how backlogged immigration is, and it is, that this will be more burdensome for the government to have to try to get all this information on one notice. They said this wouldn't even necessarily help non-citizens. Getting one notice as opposed to two notices is not necessarily going to be that helpful to them. And they considered that because he did receive a notice to appear, and then that later notice of hearing that together did have all the information that's required by the law, that should be enough to trigger the stop time rule. Just whether it was two notices versus one, who cares? He got the amount of information needed. And then they stated because he did receive that written notice before the 10 years in the US, then he can't get cancellation of removal or should not be eligible for cancellation of removal. But this is 3 judges as opposed to the 6 that ruled for Niz-Chavez. So the majority opinion from, quite conservative Supreme Court was in favor of Niz-Chavez and in favor of him being able to receive cancellation of removal. And the effect of this is that the government must now include all required information within the initial notice to appear for removal, including the charge and the hearing date and time. And if there were defective notices to appear, that can now potentially be a basis to reverse a case as well. I'm going to stop the share. So I'm just going to give you a little bit of like the on the ground perspective on this as well. Why does this matter about having one notice to appear versus 2 notices to appear? I'll just tell you what was happening on the ground. And this was during the period from like 2018 to 2020. The immigration courts became very, very backlogged over time, so that people were not able to actually get their hearing for maybe a year or so later. And that under the Trump administration, they also limited the amount of hearings, meaning that the backlog grew. And at the same time, a new practice started, where the new practice that began was the government would issue a notice to appear to somebody first. And let's say they would get that January 2018. Then they would never get that second notice of hearing for a long period of time, not 2 months, 2 years, 3 years later, do they finally get the notice of hearing, right? That tells you, oh yeah, and by the way, we now have a hearing date for you. So why would that be done? Why would they do a notice to appear like 3 years before you would even have a hearing date available? It was specifically being done just to cut off the time, right? To cut off the time right away, as opposed to waiting until that they actually had a hearing date. But what this meant was when there's that 2 to 3 year gap, the second notice doesn't have to be served. It can just be mailed to the last known address. And the effect of that was that a lot of people never got that notice of hearing, the actual notice that tells you your hearing date. 2 or 3 years later, you may have moved, right? A lot of things could have happened. And so a lot of people were not actually getting their hearing notice that tells them when they have to actually go to court. Problem being, if you don't show up for that hearing, it's an automatic deportation order, automatic, for you not going to that hearing. So this had a lot of real world consequences in terms of people not knowing about when their hearing would be, and then potentially having an automatic order of removal issued against them. So now with this new ruling, what does it mean? It seems very minor, but you can sort of see why it matters a lot. So now the government has to issue one notice to appear. altogether, it says, okay, we are starting removal process. Here's the reason for the removal, and your hearing will be on January 23rd, 2022. So now that person has all the information they need to know in order to actually go to that hearing, in order to present whatever defenses they may have available. And I just wanted to highlight one thing regarding this case is with cancellation of removal, something I mentioned before, and I want to mention it again. It's really honestly one of the only remedies available for people to be able to receive a green card, especially if they entered without inspection. It's very difficult to get status. Cancellation of removal is one of the few available. So if somebody is out of status or is undocumented, if they've been here at least 10 years, is a possibility there that they may be eligible for cancellation of removal, even if they're not eligible for anything else. And you can see in this example where he was actually able, that was what was successful, was him actually applying for cancellation of removal, and receiving his green card that way. Okay. So I'm going to pass over now to the next case. Okay, so the next case the Supreme Court heard this term was called Sanchez versus Mayorkas. And this case was about whether people who got temporary protected status can actually then get a green card. And we'll review too the topic of what is temporary protected status. What does that mean? It's another type of immigration remedy that's a humanitarian immigration remedy. So first I'm going to just go through the facts, same thing. Go through the facts, then we'll go through what these different types of immigration remedies are or options, and then going into the Supreme Court case. So we've got Sanchez versus Mayorkas. Mr. Sanchez and Mrs. Sanchez entered the United States without inspection from El Salvador. So as of 1997, they were undocumented. They had no status in the US. Then in 2001, El Salvador received what's called TPS status, temporary protected status. I'm going to go into what that is. It's a humanitarian type of remedy. And the Sanchez's then applied for and received TPS status. So then in 2001, they received temporary protected status. Then in 2014, the Sanchez's applied to then what's called a just status to lawful permanent residency. They applied to receive a green card then after being in the US for a long period of time with TPS status. And that petition was denied. And the USCIS, that's the division that approves green card petitions, said that you can't get status, you can't get a green card because you were never admitted to the United States. To get a green card, you have to be admitted to the US. And they said they were not admitted to the US back in 1997, right? And the fact that they got TPS later doesn't change that. They're still not admitted to the US, which means they're not eligible for a green card. The Sanchez's appealed that to the district court level where they won. And then the government appealed that to the Third Circuit where they won. And then the Sanchez's appealed that up again to the Supreme Court. And the Supreme Court heard arguments on April 19th of this year. And then on June 7th of this year, the Supreme Court issued their final ruling. So first, I'm going to talk a little bit about temporary protected status, TPS. What does that mean? Here we have the Sanchez's receiving TPS status in 2001, right? What is that? Temporary protected status is a type of status given to people that are essentially due to emergencies or some other type of disaster, military occupation, that means that they're not going to be able to return to that country. So temporary immigration status provided to nationals of specifically designated countries that are confronting an ongoing armed conflict, environmental disaster, or extraordinary or temporary conditions. So for example, this is something that is declared on a country by country basis. So if there is a disaster, we see this most recently, for example, with Haiti. If there is an earthquake in Haiti, the government can declare, of the US, can declare temporary protected status for Haiti, which means that Haitian nationals that are inside the US can then apply for and receive TPS status. But it's based on the country that you're from. And what do you get with TPS? You get a work permit, so you can work in the US, and you get a stay of deportation, meaning that you won't be removed from the US as long as you have the TPS status. And the DHS secretary makes the decision whether to grant. He has discretion. Essentially, this is done with the authority of the president. The president decides whether to issue TPS status on a case for each country. And so, for example, for Haiti, that was recently renewed for 2021. So what would be a reason to receive TPS designation? This is from the statute. So this would be an ongoing armed conflict, like a civil war, if there's a serious threat to the personal safety of returning nationals. You could think of the example of Syria, the Syrian civil war, where it would be very dangerous for people to return to that situation. An environmental disaster like an earthquake, a hurricane, epidemic that results in substantial or temporary disruption of living conditions, and which means that the foreign state is unable to adequately handle the return of its nationals, or it has sort of a catch-all provision, extraordinary and temporary conditions in the foreign state that prevent nationals from returning to the state in safety, unless the US government finds that allowing people to stay here would be contrary to the US national interest. So most generally, it's used for natural disasters, environmental disasters, and war, situations where there's some sort of catastrophe happening in that country, that people who are currently in the US would be able to apply for TPS status and not be removed back to that country. Okay, so who currently has TPS status? These are all the countries that currently have TPS status. And you can see that there's not too many. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. We've got 12 countries currently with TPS status. So what that means is that if you are somebody from, here we have Syria, for example, and you are in the US, you can apply for TPS status from Syria based on the civil war and receive TPS status. You could do this like even if you were undocumented to begin with, or let's say you're here with another visa, and you have a student visa, for example, that may be ending. You can apply for TPS status to prevent you from being removed. One key factor with TPS is that it doesn't let people arrive to the US. So for example, people from Syria that are now in Syria can't come to the US because the country has TPS status. All it means is that Syrians that are already here are protected from removal while there's TPS status, based on when the TPS status was approved. Okay, so we see our list here. In the facts, it said that the Sanchez's were from El Salvador. Okay, we see El Salvador here as a country with TPS status. El Salvador received TPS status back in 2001 due to a series of catastrophic disasters there, volcanic eruption and earthquake, as well as ongoing armed conflict, civil war. And that has been renewed continuously since then. Okay. So you can remain in the US. What does TPS give you? You can stay, you can work, you can't leave the country. You don't get a visa that allows you to come and go from the United States. You can't get citizenship. It just means that those that are there in the US at the time of that designation of TPS status can remain, but it doesn't let people from that country come to the United States later. So someone from El Salvador couldn't come to the US now and claim TPS status. It's only for people that were in the US when that original designation was made. So here's the question. If you have TPS status, can you later apply for a green card? Can you apply for lawful permanent residency inside the United States? This is called adjusting status. So typically, let's say you were here with a temporary visa, and now you have married a US citizen. You're now eligible for a green card. You can apply to what's called adjust status and adjust status up to a new type of category to be a green card holder. So people that have TPS status, can they do that? So for example, if they currently have TPS status from El Salvador, can they now apply for and receive adjust status to a green card in the US? And this is not clear. So what the law requires, why it matters. If you look up the actual law, it says to adjust status and receive lawful permanent residency to receive a green card, the person must have been admitted to the United States. That's INA 245. So were the Sanchez's then admitted to the US, is TPS status considered an admission to the US? They did receive TPS status in 2001, right? Would that mean they were admitted in 2001 to the US, which means they're now eligible for a green card? And here again, you can see a lot turns on the definition of one word. And all of it's turning here on what does it mean to be admitted? Were you admitted when you get status? Or is it an admission just based on how you first arrived to the US? And so this answer is unclear. There is actually what's called a split in the circuits. So that means some of the Court of Appeals have ruled one way and some of them have ruled the other way. So the 8th and 9th Circuit Court of Appeals have ruled that yes, TPS status is an admission to the US. Therefore, once you receive TPS status, you are eligible to apply for a green card. The 3rd, 5th, and 11th circuits have said no, TPS status is not an admission to the US, so you can't now apply for a green card or anything else after that. And so we're actually in the 11th Circuit here in Florida. There's very often this sort of circuit split between more conservative circuits and more liberal circuits. Here, the Supreme Court took the case to clarify. Anytime there's a circuit split like that, where some courts of appeals are ruling one way and others are ruling the other way, that's almost always going to be a good case for the Supreme Court to take, because they want to have uniformity, right? They want to have a consistent law applied. They don't want people in one circuit to have a completely different result than people just one circuit over. So the Supreme Court took this case to clarify this question. And then, so this is the question, is temporary protected status an admission to the US? And you could sort of even think based on like what we looked at in the previous case in Niz-Chavez. Now there it was about the definition of is, right? Now it's about the what does admission mean? Where's the first place you're going to go to figure out what does admission mean? And the first place always is the statute itself. That's what's called statutory construction, the plain text of that statute. What does it mean? So here we have the issue, the way the Supreme Court stated it, whether under 1254A, which is to get a green card, a grant of temporary protected status authorizes eligible non-citizens to obtain lawful permanent residence under 1255, okay? And here is the ruling. The Supreme Court upholds the decision of the 3rd Circuit and held that TPS is not an admission to the United States. This was a 9-0 opinion. This was a unified opinion of the Supreme Court, which is somewhat rare, right? 9-0, no dissent. Supreme Court unanimously held that temporary protective status is not considered an admission to the US. And the opinion was authored by Elena Kagan. The holding is that a TPS recipient who entered the United States unlawfully is not eligible for LPR status merely by dint of his TPS. So for example, if the Sanchez arrived unlawfully in 1997, received TPS in 2001, just because they later got TPS in 2001 doesn't mean that they have now been lawfully admitted to the US. And there's the reasoning here. So, okay, you're gonna have to figure out, this is how lawyers are. The question is, are you admitted with TPS status? You're gonna have to figure out what does admitted mean? What is the actual definition of admission? So if you were to look in the green card, the statute for the green card, it states there that you must be admitted to the country to be eligible for LPR green card status. And then here is the actual definition. So it has here a statute 1101A13A. That's a statute where the Congress just put a whole bunch of definitions for a lot of immigration terms that they would be using in other statutes to sort of lay out what do these terms mean. So this is the definition of admission there. It's defined to mean the lawful entry of the alien into the United States after inspection and authorization by an immigration officer. And that's the statute A13A. So if we apply this definition to the Sanchez's case, what does that mean? Here, when the Sanchez's actually enter the United States, here it says lawful entry. When did the Sanchez's actually enter the US? That would be 1997, right? When they first came to the United States without status. That's when they entered the US, physically came to this country, right? So at the time they entered the US, they were not inspected, right? The entry to the United, which it says here would be lawful entry, would be that you were inspected at the border or at the port of entry. that you were authorized by an immigration officer. So here, his entry to the United States was not authorized by an immigration officer. There wasn't a Customs or Border Patrol agent that was, stamping the passport and saying, you're good to go, you can come into the United States. Therefore, they did not have a lawful entry under this definition, right? So the definition for admission goes back to literally, how did you come to the country? In reality, how did you enter? Was it lawful or unlawful? To be a lawful entry, you had to have been inspected and authorized by an immigration officer. Here, they were not inspected. Here, there was not authorized by an immigration officer when they came in 1997. Therefore, they did not have a lawful entry, okay? So under this definition, were they admitted? Was there a lawful entry? No, right? If you need a lawful entry to be admitted, are they admitted? No, the Supreme Court found. They entered unlawfully, therefore they are not admitted to the United States based on this definition that goes to how did you actually arrive to the US? And so the Supreme Court held that that temporary protected status that they later got in 2001 does not eliminate that prior unlawful entry. So even though they did get status later in 2001, that doesn't erase the fact that they did not lawfully enter the United States. Therefore, they were never legally admitted to the United States, even though they came here, right, 1997, even though the US government gave them temporary protected status in 2001, during all this time, they're still not legally admitted because they don't meet that definition of what would be considered an actual admission. So for that reason, the Supreme Court held that the TPS status does not mean that they had been admitted to the US. And that means, if we go up here to this very first point, you've got to be admitted to the US, right, to be able to apply for LPR status or green card. They were not admitted to the US. Therefore, they are ineligible to apply for lawful permanent resident status, okay? So this is an example where you see here a 9-0 opinion by the Supreme Court. That's, like I said, that's unusual. And you can see the difference from the other case, well, where there was a 6-3 and a pretty strong dissent. And I think what you can see here is the importance or the value of having a clear definition, because here we did have a definition that was fairly clear, right? Whether you agree or disagree with that definition, the definition says, how did you enter the US? Here's the two things you have to show that you had a lawful entry. If you don't have those two things, you're not a lawful entry, you're not admitted. And so because the statutory definition was fairly clear, I think this is what helped the Supreme Court to come to a pretty unified opinion. You can see when the statutory definition is not clear or there's different interpretations, that's where you have these really strong sort of dissents and strong differing opinions in the Supreme Court as well. So I'm going to do a stop share here. Yeah. So I think for both of these, you can see, I just want you to highlight for a little bit for TPS status. TPS status is available. If you're somebody from one of those countries, you may be eligible for TPS status. You can apply and you get a work permit, you at least won't be deported, but your ability to get other types of green cards, et cetera, after that may be very limited. And now, especially with the new rule under Niz-Chavez, this does mean now that the government will have to issue one notice to appear that has all the information somebody needs in order to actually appear and present a defense in a removal hearing. And I also just want to highlight a little bit what cancellation of removal is. And it is a defense available if somebody's been here for at least 10 years that they can potentially use to protect from removal as well. Okay, I think I'll stop there. Does anybody have any questions on that? John?
Yeah, I have 3 questions on the Niz-Chavez versus Garland case. The first one is the validity of appealing it on behalf with regard to the United Nations Convention Against Torture Relief, which he did in 2013. And of course, his hearing wasn't ultimately held till 2017. Does that have any standing, the convention for torture relief? I didn't know the consequence of his appeal on that regards.
It is.
Second, yeah.
Oh, sure. I'm going
Well,
to
I have 2 more questions. The second one is just a general question of why should someone get preference when they snuck into the line that exists for giving valid visas to come to the United States for immigration. And that strikes me odd. And the third question on that case is basically, can the government correct an error in a notice of removal? Can they just say, nope, we didn't put all the facts in our first letter. This second letter has everything required. Or do they, if they make that mistake in the first, notice of removal, are they then unable to correct their mistake? Those are the questions I have.
Very good questions. I think I'll go backwards from the last
Okay.
one in the back.
Yeah.
So can the government correct the error in their notice to appeal? Yeah, they can. They can issue a new notice. It's like, oops, we messed up. And now here's the elements we have to put in there. The date they send out that correct notice to appear is now the cutoff date. So they send that correct notice now, July 1st, 2021, right? That becomes now the actual cutoff date. It won't be based on when they sent that defective notice. So you can correct it.
Didn't they do that in that second letter they sent, which gave the date and time, or was that still insufficient back in 2013? They sent one letter which merely said, which is a kind of an intimidating letter, which says you're going to be removed and we don't.
Who knows when or why? Yeah.
Which may have an effect, but that second letter seemed to have all the information necessary for the hearing.
The problem is that it wasn't a notice to appear. So a notice to appear is almost like a summons, right? So they first sent a notice to appear, then they just sent a general notice of hearing. That's what they always send. Like, let's say they did properly serve you and everything, and now there's a new hearing, they just send you a general notice of hearing.
Okay.
So that's what they did. They didn't just send a full notice to appear again, like a new summons that has all of that required information. And why does this matter? This may seem nitpicky a little bit, but you'll see this over and over, not just in immigration, but in criminal and civil cases. It's because that summons or notice to appear is your due process right under the Constitution, right? Mm-hmm. Which means that your life or your liberty can't be taken away without due process. Due process means you have to have an opportunity to know the government's making charges against you, know when that hearing is, so you can appear and defend yourself, right? That's constitutional. So that's what all of this goes back to, is like your constitutional right to be actually able to defend the charges against you, and whether a notice to appear that has the elements so you know what you need to do, as opposed to a piecemeal approach where you just know you're going to be put in removal, you don't know why, and then later finding out your hearing date a year later, right, will be impacting your ability to defend yourself. Yeah.
Sure. How about sneaking in the line?
Sneaking in the line. So I will say, so the cancellation of removal, there's two types. One type I mentioned is for people that are here legally, and that's not so hard to get. There is cancellation of removal for people that are undocumented, right? It's super hard to get. So one is that you have to show extreme hardship to a US citizen, not that you'll be killed if you go back, but essentially that there's somebody that will almost die if you don't go back. Like if you're a caretaker for a disabled child, et cetera. Yeah. And there's also not many available. So there's a cap every year on that. And so what this does mean is that immigration judges will tend to only use this for really extreme examples. As it's not necessarily even meant so much to help that immigrant as to help that US citizen that is dependent upon them. Yeah, and so that's really why you get that limited exception.
That was the fourth criterion. That's right. And then finally, the UN Convention Against Torture and a request for relief.
The UN Convention Against Torture does apply. So we've signed the UN Convention Against Torture, right? Which means that we've agreed that we will not return somebody to another country where they will be tortured, right? It's kind of similar to asylum. It's not asylum though, it's something different. It's just this one convention on torture. The one problem with it is that it's not easy to get, because you have to show like 75% likelihood you will be tortured. Not just that you have a fear of it, not just that, you know, there's a possibility or even a probability. You have to almost show a surety that this will happen. That's why it's a difficult thing to claim. And you also have to show not just that you'll be tortured by a paramilitary group, but that the government itself in their own laws will allow you to be tortured. So in practicality, it's a really hard case to make, even though we are part of it, right? But this is why you don't hear about it so much. It's almost used as a last ditch effort. If there's
It's
somebody
kind of a special TPS.
Yeah, a special TPS. I mean, it's a humanitarian thing where we've agreed if somebody's going to be tortured, they should not be removed back to that country. And so, yeah, that's part of it, but it's not an easy case to make.
Thank you.
Hey, Anastasia, this is Julianne. I'm in the Oak Room here and I have a question and then we'll get to David up on the Zoom screen.
Hi, Anastasia. Thank you so much for such a great presentation. Very clear. I used to volunteer with the Friends of Baker Detention Center. And in 2019, in talks with approximately 10 or 12 people, their average length of stay in the US averaged 17 years. Some of them were much, much longer. There was one particular case I'm interested in your opinion on. This woman was brought to the US by parents when she was 8 years old. And her thought, because she came through an airport and she thought she was in the country legally. She did have a green card at one time, and I think it had expired, but she had married, had children, and she was not able to afford a lawyer, and she was deported. Would she have had any standing? As far as I know, she had never have been in any trouble.
I just want to comment like what you said about the average length of stay was 17 years for people that were then put into deportation that were now at the detention center, right? So this is a common scenario where people will be here for very long periods of time. And that's why I sort of highlighted the cancellation of removal. It's because it is one of the really only ways those people may be able to get status, right? Because otherwise the deportation process, it's not very humane. You know, that doesn't care if you've been here 20 years. If you don't have status, you can be removed. And I can't give you specific details. This is how lawyers are. I can't give you specific advice about this specific case because I don't know all the details of it, et cetera. But I can generally say, if you were brought to the US as a child, they had the option of DACA, right? Which the Trump administration ended. It may now be reopening. But that wasn't open for new cases, new applications for a long time. And if you were, I don't know if you had a green card, how you could lose a green card. Usually green card is permanent. But if you were out of status, let's say you had a visa and your visa expired and you're now out of status. After you're out of status, you're deportable. Even if you had that status for a very long time, you had a visa for many years. Because it's a civil system, it's not considered to be a criminal charge in any way, right? So you don't have to have done anything wrong, quote unquote. You just have to be here, not a citizen and not with status, and then she could be removed potentially. Now, if she married and had children, if there could be a potential there for a cancellation of removal based on the children. And I don't know the circumstances for how you thought you came in, like in the airport, but that's what I was talking about with admission. It goes back to were you lawfully admitted or not, you know? And I have seen these situations sometimes where kids don't know how they got here. Like their parents just say, yeah, we just, you know, we came from Hungary and we went through the airport, and they may not know all the circumstances of that case. Like, were you technically admitted or not? And it's often quite a shock to them, like 20 years down the road when they want to apply for and find out they're undocumented, you know, because they were not lawfully admitted. Yeah, so that's often the case. And that's why if you're an immigration attorney, what you actually need to do is really dig into those records to find out how was she entering the US when she was 8? What was the admission that she had at that time? Because that's what matters a lot. And one of the things, if you entered undocumented, if you entered without admission, you are very much barred from a lot of other things. And so you could be here 20 years and then eventually be deported. It's sad, but that is the way it works. It matters a lot how you got here. Okay,
Thank you. How are you on time, Anastasia?
I think I'm okay, but I don't know if you guys are okay. How long would you want to go?
No,
to?
we're okay. I just didn't want to hold you. So David, you're next. If
I
you'd
need
like
to
to.
go by 3, but up until then, it's fine.
Okay. Thank you.
Thank you for a really clear presentation. Just one question. once or twice a month, I receive a mail that is addressed to somebody else. That is, it was addressed to me in error or sent to me in error. So I put it back in the mailbox with a note to please deliver it to the correct address. And I hope that this isn't happening to me too, and I'm not getting the courtesy of somebody resending the mail. But what happens in a case where a letter to appear is never received?
Very good question. Very good question. And one of the differences with immigration as opposed to like a civil or criminal, if you look at a civil criminal summons, it generally requires what's called personal service, which means the sheriff has to knock at your door, give it to you, confirm that you are the person that's on that named on the summons, right? And then they make sure you are actually served. If you look at the notice to appear, it just requires them to send it to either personally or via mail, right? And so the answer to that is that if they send the mail to the last known address, that's good enough for notice to appear, even though it is a summons, right, to actually appear in court. And it's considered to be, the burden is on the immigrant, as it often is, to timely notify USCIS and ICE and everybody else in the immigration system every single time they move, every single time they change their address for any reason. You're supposed to notify the immigration authorities so that they have a new address for you, so they make sure to send that address to you. A lot of people don't know this, right? But that's the answer to your question is the burden is on the immigrant. So if you moved, right, 2 years ago and you didn't necessarily notify the right people, and they send that notice to appear to the last known address they had for you, that's valid service, valid service. And what this means on a practical level is like you would be shocked at how many people have removal orders against them and don't even know it, right? Because it just goes to their last known address where they lived 3 years ago. They didn't show up for the hearing they didn't know about, and now there's a removal order. And they don't find out until like they get picked up somewhere and informed there's a removal order and we're deporting you. It happens more than you may think, but it's because that they don't have to show personal service. Yeah.
Okay, thank you. Roxanne, if you'd unmute and ask your question.
Nope. Different button.
Okay. My question is there a way to get off the TPA's status and onto a more permanent status? Or how easy is it to do that?
It's not easy. TPS status, I have like, I guess I have a conflicting opinion on TPS, right? TPS status, yes, it does give you temporary status, meaning you're not going to be removed from the US. You can work in the US during that time period. But because, as we see in that opinion, it's not actually an admission because you got the TPS status, right? You're not generally going to be considered eligible for a green card. You're not generally going to be considered eligible for other types of visas. What you would actually probably have to do if you wanted to do any of those things is that you'd have to leave the US, go back to that country that you're afraid of, right, where there's the disasters, and try from there as if you never came to the US at all, right? And try again now with a new application for some of it for green card or for visa, which is very difficult to do. Yeah, but that's the problem with TPS is that, yes, it does let you stay here, but you're in this limbo a little bit, right? Because you never know when that can end. TPS status is renewed annually for 18 months. So you only know that you're still good for 18 months after that. After that, they could decide not to renew it and you're undocumented, you're removable, you know, and you never know when that can happen. So people with TPS do end up being in a little bit of limbo. And it's why as well, there's always, you can see a lot in the news where there's always a big fight, really big discussion when they're considering ending TPS status for a country, because that means that those people who have now been here for many years and have, you know, families and businesses and everything else are now all going to potentially face removal. So it becomes quite contentious.
Okay, Lynn, go ahead.
Yeah, thank you for your presentation. I thought it was very interesting. I had a question about the dissent on the Niz-Chavez case. And I was a little surprised that Alito was on the dissenting side because I always thought of him as more of a textualist. Maybe you can comment on whether there was unification on the dissent side or whether there was some difference of opinion.
Well, the dissent itself was authored by Kavanaugh. So Alito didn't issue his own opinion. He just signed on to Judge Kavanaugh's opinion. And so I think what was probably, what's consistent there is that there are all conservative, quite conservative justices. And what Kavanaugh specifically pointed to was they really didn't even address so much, honestly, they didn't address so much the technicalities, like you talked, the textualist argument, or what is the actual text here, four corners of the text, Scalia type argument, right? They talked a lot about the logistical challenges. They talked about how the burden that this would place on the courts to be having to do these notice to appears, about how that this would prolong the process for removal, right? And what kind of surprised me is them talking about how actually he shouldn't have been able to get cancellation of removal at all. Sort of a lot more, logistical based arguments, administrative convenience based arguments, and a little bit there too as well of, I could almost say a little bit of almost like to John's point, it's like, is it really fair for this guy to be able to get a green card now? Like you could see that a little bit in that opinion as well. But that's really what they based it on. They really didn't go back to the four corners of the text type argument. And I think that's because, there's a reason 6 Supreme Court justices ruled in favor, right? Like they all agreed that the text that Congress approved was quite clear, at least in their opinion. Yeah. Good question. Yeah, thank you guys all for your attention and your excellent questions.
I just wanted to add one comment, and Anastasia spent some time talking about statutory interpretation and how one word can make a difference. And if you focus on the decisions of the court, you will see this again and again and again. And one of the things I want to bring to your attention, which I hope Meredith addresses when she does her presentation on the gun legislation and how it's arisen and where it's going, is that you're not going to believe this, but we are where we are because of the interpretation of a comma in the Second Amendment. And there have been treatises and books and everything you can think of written on what that comma means. And depending on which side of the wall you fall on, you can agree with what has happened, or you can absolutely disagree. But what has happened is the interpretation of the Second Amendment really has turned on a comma. So when Anastasia was talking about what the word or what the A meant in the first case, it's right on point, because a lot of these decisions turn on one word in a piece of legislation that's been passed by the Congress, and probably something they never thought about. And in terms of the Second Amendment, in terms of what the founding fathers thought they were doing and what they did not think they were doing when they wrote the Second Amendment. You might just think about that when you're looking at some of these cases and how we end up with the decisions we end up with. Anastasia, thank you so much. These are difficult cases and you presented them very clearly. So I think that everybody can understand what happened here. I think they have lasting impacts for a lot of our immigrants. And they are a way for them to get permanent status here in the United States without the fear of deportation hanging over their heads. So I wish you all a good afternoon. And if you have any questions, feel free to contact us and we will try and answer them. Thank you.
I enjoyed speaking with you all.
Thank you so much, Anastasia. Everyone have a great afternoon.